Charles Chevelle.
Thank you, Mr Speaker. Mr Speaker, I want to say a few words about the motion that the Minister moved. And I guess my fundamental point in this contribution, sir, is to say that the opposition accept that there will be occasions when these sorts of motions are appropriate. Just the other day, we had a motion to truncate the scrutiny that would be able to be afforded a subordinate legislation, confirmation and validation bill. The proposal was that that should go to the Regulations Review Committee and it should come back to the House on the 5th of November. Now, the committee met this morning and we had a look at the strictures that would put on our ability to consider the bill. Basically, because it was pretty much a procedural piece of legislation, we worked out that we could accommodate the House's instruction. And I had been given the courtesy as the chairman of the committee in advance from the relevant minister by way of some advice that that was what the government wanted. They wanted the legislation back quickly. We couldn't see any harm in that, sir. There was no great controversy in the legislation. It was a procedural bill. As I say, we worked out in the committee today on advice that we could, without appointing advisors, we could write to the departments concerned and ask them for evidence by way of a written response to questions.
Now, I think the member's talking about a different bill here. I'm having difficulty following him, but we are discussing the reasons for this. Charles Chevelle.
Well, sir, speaking to the point of
No, I've made a ruling, and I'm seated. I'm listening. The member should continue.
And sir, I apologise if you think I'm straying. What I'm trying to do is draw an analogy between a situation where it's entirely proper to do this and the present situation. And I am going to get to the present situation, I promise you. But I do want to make the point that we concede it is proper on occasion to do this, but it isn't, even in those cases, an easy thing for a select committee to accommodate. It is necessary to do away with the possibility, for example, as we did today, of the likelihood of hearing evidence. We're simply going to do things mainly on the papers. We're going to do without advisors. We're going to simply try to rely on our own expertise and on the evidence that we receive from departments concerned. Now, that's probably just doable in that sort of case. This legislation is substantive legislation. And the reason I've tried to draw the analogy, sir, is it calls for the reporting back of the legislation a day after the bill that I've just mentioned, the subordinate legislation confirmation and validation bill is due back on the 5th of November. I've tried to just illustrate to the House how the committee has had to deal with that in order to meet that deadline. This is a much more substantive piece of legislation, and no doubt the committee is going to have to consider the same sorts of shortcuts and abridgments that the Regulations Review Committee had to consider this morning. It will have to consider whether it can fully hear evidence, whether it can travel, whether it can hear from all the witnesses that it wants to hear from, whether it's going to get the sort of advice that would be customarily able to be tendered from officials in the very, very short time frame that is available, even if it sits through all the recesses and all the sessions of the House that lie between now and the 6th of November. Sir, I want to also just make another point about the desirability of this practice, and it's by way of trying to illustrate to the House the sort of perils that can come up. When the criminal compensation legislation was being considered by the House, the Minister had said to me that because there was an expiry date coming up, she wanted to expedite the consideration of that legislation. So there was a very good reason why expedition should occur, and I agreed on behalf of my colleagues that we would cooperate, particularly at the Select Committee, in getting that legislation through on an interim sort of fixed basis so that the primary legislation, which is about to expire, wouldn't leave a hole in the law while we considered, as a parliament, what the replacement should be. So there was a proper case for expedition. What there wasn't was consultation about whether there should be a truncation motion, just like in this case. And so when it was moved, even the acting leader of the House, the Honourable Anne Tolley, was surprised to have it sprung on her. And she was not surprised to see that there was objection from our side of the House to the truncation motion. Now that has led to, I have to say, some real difficulty in terms of the ongoing relationship between me and the Minister. The Minister feels that because we agreed to expedition but not truncation, and then when we voted against truncation because it came up on a surprise basis, she felt that we had gone back on the deal that we had. Now that certainly wasn't the case, but it's just a good example of the sort of problems that can arise in this sort of situation where without consultation a truncation motion is moved. So I just would make a plea to the Minister and to the Government to reconsider the wisdom of the truncation motion in this case. It is generally, I think, agreed to be not good practice. It should only occur where there is a good reason. I've tried to give two cases where I think there was good reason. First of all, one where really only procedural matters were being dealt with. That clearly isn't the case here. Secondly, a case where there was primary legislation due to expire and there was a need for some interim legislation to come up and be dealt with on an urgent basis. Well, again, that was clearly a case where it was justifiable to contemplate this sort of procedure, even if there wasn't proper consultation and agreement on truncation. That isn't the case here. This is very substantive legislation. And, sir, I'm not going to refer to the substance of the bill, but what I am going to say is the reason why this bill differs from the two cases that I've tried to put to the House includes the fact that it will involve a transfer of employees legally from one entity to another. It will involve the creation of a new Crown entity. If we have a look at clauses 15 and 16 of the bill.
The member's now outside. You come back to the provisions in the motion to shorten the period.
Well,
point of order, Honourable Trevor Mallard.
Mr Speaker, the motion is in fact much wider than the question of the shortening. There is the question of when it can sit. There is a question of where it can sit. And, sir, I think it is important that members are not restricted, and we've had a bit about the shortening, but I'm sure that as debate goes on, it will be about the other provisions of the motion as well.
Well, I would say nice try, but it's outside standing orders. And let me just read the standing order again. Any debate on the question for the motion under the standing order is restricted to the special powers of the instruction set out in the motion. It may not extend to the principles, objects and provisions of the bill, which the motion relates to. A point of order, Honourable Trevor Mallard.
Mr Speaker, the special instructions or the special powers or instructions that were moved, I accept that you were not in the chair at the time, Mr Speaker, they relate not only to the length of the period before the report back, but when the committee can sit in the sitting time of the House or other times.
I've heard the member. Firstly, I do have the House relayed in my office. I also have the motion in front of me, and I have standing orders, and I've instructed the member quite clearly on what he should speak on. Point of order, Trevor Mallard.
Mr Speaker, you instructed him only to speak on the length.
No.
Well, that's exactly what you referred to, Mr Speaker, and that is why I took the original point of order.
No. Well, it's the provisions that were in the motion. Well, let's be quite clear.
That's all right. That's good.
Charles Chevelle.
Thank you, Mr Speaker. Mr Speaker, I was simply making the point that while I was pointing out to the House before that there were procedural bills where this sort of motion was appropriate and where there were occasions where a bill might contain a sunset clause and where the Parliament had not moved expeditiously to deal with replacement legislation, this isn't one of those cases. This is substantive legislation. I am sure members in the Select Committee will want to hear about the effect of, for example, creating a new Crown entity, they'll want to hear from experts, Mr Speaker, about the effect of legally transferring employees from one entity to another. And so there's another point that I want to really invite the representatives of the government in the House to consider. This is a bill which has had virtually unanimous support in the House today. And the bill has been referred to as Sir Paul Callaghan's bill. Sir Paul is a person who commands posthumously enormous respect from all New Zealanders. I really think that this is the sort of case where the government ought to just pause and consider whether it wants to create a controversy like this around legislation that it regards as clearly something of a centrepiece around its economic development agenda, and one where it has invoked the memory of a very great New Zealander, somebody who does deservedly have respect across the House. Well, sir, I'm making the point that a procedural motion such as this does not do honour to the person that the government wishes to name the bill after. And it's another reason why I invite them to reflect again, as well as on all the consequences that my colleague Chris Hipkins has foreshadowed, as to whether this is a course of action that they wish to pursue.
Michael Woodhouse.
I move that the question be...
I will hear Gareth Hughes.
I rose very slowly to give the government benches an opportunity